At night, there's 8 commercials every 10 minutes. It's unbelievable. But what we really should be doing is looking at cases like this. This case is important, and it was dismissed. Dennis Montgomery versus Comey. James Comey from Connecticut. Larry Klayman from Judicial Watch, right, sued the CIA, NSA, Obama, James Clapper, Daniel Coates, Mike Pompeo, Director John Brennan of the CIA, NSA Director Michael Rogers, and former James Comey, Director of FBI. Ongoing illegal, unconstitutional surveillance of who? Personal hacking into, and they covered up a lot of wrongdoing. They hacked something like 150 judges. 150 judges, okay? Common law tort. This case was dismissed with prejudice. That means you can't bring it again against the NSA for what they did about surveillance when they used the Patriot Act to surveil surveillance of millions of Americans. See? Chief Justices of the Supreme Court were surveilled. And they used something called PRISM with FISA, ongoing surveillance, coordinating leaks of sensitive information. Wow. 47 hard drives under James Comey, 600 million pages of data. Former General Counsel James Baker, hands-on supervision of the Montgomery investigation given its importance. Wow. NSA, CIA, DNI pattern and practice of unconstitutional mass surveillance. So now I ask you, in the Connecticut 5G case, which looks an awful lot like this case, continue to harass him, fed misleading information to journalists to smear his name, exactly what they did to me, to render him an ineffective whistleblower. That's exactly what Judge Blowy, Kremrich, Kavanowski, Clark, and everyone else is doing in the Stanford Superior Court to me. Well, that's all right. Let them do it. House Intelligence Committee, targeted by defendants because these meetings. Well, I'm targeted by the State Police of Connecticut. They just stole my car. Said it wasn't registered. It was. The registration was in the glove compartment. So here we go. $235 million injunctive relief and blah, blah, blah. Standard of review. Federal Civil Rule of Procedures. Okay. Lots of civil rights violations. Motion for summary judgment. This is what the judge agreed to. Genuine issue of material fact. Casting doubt. Fourth Amendment claims. Millions of innocent U.S. citizens without suspicion or probable cause. Exactly. NSA bulk collection program with CIA malware. Well, things have changed since this case got dismissed. First of all, they sold Hammer Scorecard to China. What's the significance? China hacked the Connecticut election. The Connecticut election was falsified, and Connecticut's backdoor to the rest of the country through the Connecticut Education Network is problematic because the basis of the First Amendment claim is a practice of unlawful surveillance. And what they did was flip votes from Trump to Biden in Michigan, Wisconsin, Vermont, and Pennsylvania through an illegal hack. So you're seeing here USC 2679 shall not be construed to authorize suits against reckonable. Okay, fine. The United States is the only defendant. The United States to a claim under FTCA. Okay. So what I'm saying is they're going to try to get sovereign immunity under FTCA. And the claims are subject to dismissal. But in my case, the documents were stolen and sent to Hearst. So it's not only a Fourth Amendment violation, it's a Hatch Act violation, a HAVA Act violation. These are all federal laws. And it's maladministration, which is different. So I think, in my own conclusion, I don't care what they said here. This was the conclusion. Judgment of dismissal granted, and plaintiff's motion for preliminary injunction denied. I have a print injunction for the 2022 election based on the fact that not a single signature of mine was approved. So I gave them 57,000 signatures. They were stolen. It prevented us from being on the ballot. We qualified. And the evidence was destroyed before the 22-month holding period was up. So, what happened there? Spoliation tolls the statute of limitations, and this is an open season on these guys. Open season. And if you shoot the clay pigeon up, yep, we're going to get it. So, that's one of the cases we should highlight, because we know how we're going to prevail over what happened with James Comey the first time. James Comey is back in this case because of a different reason. He sold Hammer Scorecard to enable the hacking in the elections. And a lot of that data is going to come out hopefully by July 23rd, which is 8 days from now. So, we've added a lot of defendants, and the judge isn't allowing it. And if you noticed, they had a Judge Meyer ruling in this case. Is it the same Meyer? Because the other judge was from the District of Columbia. But in this case, we have a problem here, because the judge hearing the case has a confidential written agreement with the defendant, Richard Blumenthal, who was never named in the prior case, but in fact is pulling all the strings, because he has judiciary compliance over multiple parts, and he also is on the Intelligence Committee, which has oversight of NSA, CIA, TSA, FBI, all that other stuff. So not only did Blumenthal bring Comey down to Washington for the Hillary Clinton investigation, all these characters went to Yale. Bill Clinton, Hillary Clinton, Richard Blumenthal, in the same class. They were friends, okay? So